The Civil Code of the Philippines. Book 4, Obligations and Contracts. Title 1, Obligations. Chapter 4, Extinguishment of Obligations. Section 2, Loss of the thing due. Article 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor, and before he has incurred in delay. When by law or stipulation, the obliger is liable even for fortuitous events, the loss of the thing does not extinguish the obligation, and he shall be responsible for damages. The same rule applies when the nature of the obligation requires the assumption of risk. Article 1263, in an obligation to deliver a generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation. Article 1264, the courts shall determine whether, under the circumstances, the partial loss of the object of the obligation is so important as to extinguish the obligation. Article 1265, whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault, unless there is proof to the contrary, and without prejudice to the provisions of Article 1165. This presumption does not apply in case of earthquake, flood, storm or other natural calamity. Article 1266, the debtor in obligations to due shall also be released when the prestation becomes legally or physically impossible without the fault of the obliger. Article 1267, when the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obliger may also be released therefrom, in whole or in part. Article 1268, when the debt of a thing certain and determinate proceeds from a criminal offence, the debtor shall not be exempted from the payment of its price, whatever may be the cause for the loss, unless the thing having been offered by him to the person who should receive it, the latter refused without justification to accept it. Article 1269, the obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third persons by reason of the loss. Section 3, Condemnation or Remission of the Debt. Article 1270, Condemnation or remission is essentially gratuitous, and requires the acceptance by the obliger. It may be made expressly or impliedly. One and the other kinds shall be subject to the rules which govern inefficacious donations. Express condemnation shall, furthermore, comply with the forms of donation. Article 1271, the delivery of a private document evidencing a credit, made voluntarily by the creditor to the debtor, implies the renunciation of the action which the former had against the latter. If in order to nullify this waiver it should be claimed to be inefficacious, the debtor and his heirs may uphold it by proving that the delivery of the document was made in virtue of payment of the debt. Article 1272, whenever the private document in which the debt appears is found in the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily, unless the contrary is proved. Article 1273, the renunciation of the principal debt shall extinguish the accessory obligations, but the waiver of the latter shall leave the former in force. Article 1274, it is presumed that the accessory obligation of pledge has been remitted when the thing pledged, after its delivery to the creditor, is found in the possession of the debtor, or of a third person who owns the thing. Section 4, Confusion or Merger of Rights. Article 1275. The obligation is extinguished from the time the characters of creditor and debtor are merged in the same person. Article 1276. Merger which takes place in the person of the principal debtor or creditor benefits the guarantors. Confusion which takes place in the person of any of the latter does not extinguish the obligation. Article 1277. Confusion does not extinguish a joint obligation except as regards the share corresponding to the creditor or debtor in whom the two characters concurred